So, should you protect your invention with a patent or keep it in-house as a trade secret? Hi, everybody. I'm JV Houvener, owner, founder, and patent attorney at Bold Patents Law Firm. I've helped inventors now for over 10 years, helping them achieve nearly 500 patents as of today. I'm also the author of Bold Ideas, The Inventor's Guide to Patents. It's a great book that's published back in 2021 and is going to be updated this year in 2025. A new PDF is downloaded in the link below, the Bold Inventors Kit. Grab that link and get yourself a leg up over your other inventor peers that don't have the tools and training on how to file and prepare for their own patent process. In there, you'll find my guide for how to move forward through the patent process, from searching, application drafting, all the way through working with those examiners. It can be quite tricky. All right, let's get to this topic of patents versus trade secrets. When to do a patent, when to maybe think about holding off and keeping things as a trade secret. Let me first start with some definitions. When you have a trade secret, that means you've got a competitive advantage over your competition. It means you have some knowledge, some expertise, some know-how that you figured out a way to have a better product, deliver a better service, or have information that is immediately valuable to, let's say, the competitor. They want that information, and so you want to keep it secret. How do you do it? Well, you protect it with internal documents, starting with contractors, employees, and anyone that has access to that information. You need to keep it secret. Of course, if it's physical, which usually they're not, they're almost always digital or up in the cloud, stored as software, you've got to protect it with state-of-the-art technology to show that you're keeping it secret. Moreover, you need to make sure you label those documents on the top very clearly. This is confidential. This is proprietary. This is trade secret. You can't just necessarily give everyone in the company access to these documents. Keeping it secret means limiting the disclosure, because the worst case scenario is it gets published. One of your employees gets upset, quits, walks away, and goes and tells the world about it. Sure, that is a violation of trade secret law under misappropriation, but your trade secret's gone. It's out. And now you're after litigation over the one employee that burst the bubble. So trade secret can be quite valuable, and there's a lot of good things to think about. We'll get back to it later. Now, with patent law, of course, it's public. As soon as you file your patent application, a year and a half later, when you go through the process of getting the patent granted, it will be published. That is part of the trade. You're telling the world how to make and use your invention. And in exchange, you're getting a limited monopoly, being the only one allowed to make, use, or sell your invention. This comes with a risk, of course, that as soon as the information gets published, other people can look at it, see it, and try to design around it. So you really want to make sure that if you're going to move forward with a patent, that you have a rock solid market share. And what you're going for is going to let you leverage and make money in the market. Before you move forward, pull the trigger with an application, get with a patent attorney, talk in detail, not just about the technology, but what's your plan to go to market? How do you want to proceed forward? And what is the impact going to be on competition if and when you start business, launch, and try to grow it? So the biggest test, and here's the takeaway, is the reverse engineerability test. Whether to move forward with a patent now or keep it as a trade secret. Your product as it is today, if it is built and sold on the market, the novel features, if you sold it and a competitor bought it, would they be able to reverse engineer that product and find out what it is you did that made it unique? If the answer is yes, for sure, or even if you're leaning that way, it's more than 50% chance that they would figure it out. You want to seek patent protection for it, because that is the heart of what patent law will do. It'll prevent them from making, using, or selling it, or they face infringement charges against you. Now, take it the other side. If after making, using, or selling, making that product, you don't think there's any way that a competitor could figure it out. Maybe it's the software, and there's no way they could actually know the source code or the method or process you followed, even after you sell the software as a service. That may be a secret, a trade secret, something you can keep in-house, because it's not easily reverse engineerable to make and use, right? So you want to be able to know whether something is reverse engineerable, to know whether you need to patent it right away, or whether you've got some ability to keep things as trade secret, mainly because it's not going to be detectable. So that's a cool test to check out. Also, get a hold of us. at boldpatents.com. Click the link below, download your Bold Inventors kit to get started learning about these types of things and whether to keep things as a patent or as a trade secret. Everybody have a great rest of your day. I'm JV Houvener with Bold Patents. Go big, go bold.